a couple of hours in the Senate. We appreciate you being here, and you have the floor. Minister Holland, please go ahead.
Thank you very much, Mr. Chairman, and good to be back in front of the Health Committee. We did just have a very productive session the last couple of hours with the Senate, getting an opportunity to talk through, which is a very delicate and sensitive issue, one that requires a lot of calm, patient deliberation. And I appreciate members of this committee for their input and work. I certainly appreciate the work of the Joint Committee as we attempt to navigate this very difficult issue. I think I'll start by making a very clear and important distinction, and that is between mental health and mental illness. Mental health, not only in Canada but across the world, is in a state of crisis. Coming out of a pandemic, dealing with the rise of very devastating wars, global economic uncertainty, the existential crisis of climate change. These are difficult times to be a human being. But the challenges that we're faced in mental health are completely separate and apart from the issues that we're talking about in Bill C-62 with respect to mental illness. And that distinction is an important one because a conflation is both dangerous and I would represent irresponsible. When we talk about mental health, the historic investments we're making in mental health across this country, cooperating with governments of every stripe. You know, I had an opportunity just yesterday to be in the Northwest Territories and announce our bilateral agreement on both aging with dignity and working together. The day before that was in British Columbia, announcing our Aging with Dignity agreement there. And of course, have already announced a working together agreement with BC, with Alberta, with Nova Scotia, with PEI, and many more to come, with specific and detailed plans of how we're going to take on the challenges we're facing in mental health. But when we're talking about mental illness, we have to recognize that there are some people who are trapped in an irremediable situation where their state of illness is not able to be remedied through medical intervention. And so we have to ask the question as a society, indeed as a parliament, at what point do we allow a person on their own recognizance, if they have an irremediable condition, to be able to make the choice to access MAiD? If somebody has suffered for 10 decades, for 10 years, 20 years, 30 years, 40 years, where they've tried absolutely everything, where they've gone to medical practitioner after clinician, after expert, and have never been given the opportunity to escape that mental hell. When it is an illness, not a momentary mental health crisis, what do we do as a society? And that's what we've been trying to navigate. The decision we have in front of us now is to ask for more time to prepare the system. I've had opportunities to talk with health ministers. We had a very constructive conversation in Charlottetown when I was together with all health ministers, Mr. Chairman, in your home province, discussing how we navigate that, how we get the system ready. And frankly, we need more time. We need more time for Indigenous engagement. We need more time to work with provinces and territories to make sure they have appropriate safeguards. Talking with CAMH, we want to make sure that if there's a possibility that clinical guidelines are required to create uniformity across the country, we have opportunity to explore that. We need more time to work with the disability community and with the community of folks with lived experience. So a 3-year pause is appropriate so that we can deal with mental illness, which is separate and apart, and I'm welcome to have the conversation on mental health, but hopefully tonight people will not be conflating those two. Because they are two separate conversations. But we do need time, and I'm appreciative of the opportunity to be before a committee tonight, to have that conversation, Mr. Chairman, to take your questions, the questions of the committee, and to have this conversation. Thank you very much.
Thank you, Minister Holland. Minister Varani, welcome to the Health Committee. You have the floor for the next 5 minutes.
Thank you very much, Mr. Chair, and I'm pleased to be here to speak to Bill C-62, which proposes to delay the expansion of the eligibility of MAiD to persons whose sole underlying medical condition is a mental illness for 3 years until March 17th, 2027. As members will be aware, this bill would also require that a joint parliamentary study be undertaken on the topic by a mixed committee of senators and MPs approximately 1 year before the new date of expansion. The very first thing I wanted to start with is by expressing my sympathy for anyone experiencing intolerable suffering. I want to acknowledge that mental illness can cause the same level of suffering as physical illnesses, and that having a mental disorder does not mean that an individual does not have decision-making capacity. Everyone deserves dignity and respect. As this Health Committee is aware, the Supreme Court of Canada's decision in the Carter case led to the legalization of medical assistance in dying in Canada. In that decision, the Supreme Court declared the Criminal Code absolute prohibition at the time on physician-assisted death to be unconstitutional, noting that it should be available to competent adults who clearly consent to the termination of life and who have a grievous and irremediable medical condition. That led to Canada's first MAiD law in 2016. Many members were here with me in 2016 when we enacted that law, which restricted eligibility for MAiD to persons whose natural death was reasonably foreseeable. Quelques années plus tard, dans la décision Truchon.
A few years later, the requirement that natural death be reasonably foreseeable was found to be unconstitutional by a Quebec trial court in the Truchon decision. The federal government did not appeal this decision. Instead, it made the policy decision to introduce former Bill C-7 to expand eligibility for MAiD to persons whose natural death is not reasonably foreseeable. This bill, as introduced, permanently excluded persons whose sole underlying medical condition is a mental illness from being eligible for MAiD. During its consideration of the bill, the Senate made an amendment to make this exclusion temporary. The House agreed, and the bill as enacted would have automatically repealed the mental illness exclusion 2 years later.
That the government's decision to go forward with those expansions at the time was a matter of social policy. I appreciate, though, that there are those who believe that the Charter required us to act in this regard on mental illness, and I want to address this point directly. MAiD is a complex and deeply sensitive topic, and there are important Charter-protected interests that arise in this area. On the one hand, there is the autonomy and dignity of individuals in making end-of-life decisions. On the other hand, there is the protection of those who are vulnerable and who might be at risk in a permissive regime. In its decision in Carter, the Supreme Court recognized the complexity of legislating in this area and suggested that Parliament's choices on how to balance these competing interests would be given a high degree of deference. MAiD is a particularly complex in the context of mental illness. As noted in the various MAiD-related Charter statements, these inherent complexities are the basis for the mental illness exclusion. Some of the complexities, Mr. Chair, include that the course of a mental illness may take is more difficult to predict than that of a physical illness, and many people with a poor prognosis will improve, at least in terms of their suffering, which may alter or impact their wish to die. Moreover, distinguishing between suicidality and a valid request for MAiD becomes particularly challenging when suicidality may be a symptom of the mental illness that led the person to request MAiD in the first place. The MAiD mental illness exclusion is not based on harmful assumptions nor stereotypes about mental illness. We recognize, as Minister Holland has just said, that the suffering mental illness can cause is on par with the suffering that physical illness can cause. This exclusion is not a denial of this fact. We also accept, as I said at the outset, and as I will repeat here again, that the decision-making capacity of those who are mentally ill is well established. As we have said, we do believe the exclusion should be lifted when the healthcare system is ready to manage the inherent risks and complexities of assessing requests for MAiD that are based on mental illness alone. Our provincial and territorial partners agree that more time is needed. Medical experts agree that more time is needed. The lack of consensus on this issue proves that more time is needed. This bill reflects the caution required to ensure the safety of Canadians and get this right. As the interests at stake are significant and the consequences, Mr. Chair, are permanent, we must get this right. Thank you very much.
Thank you, Minister. We will now begin with rounds of questions, starting with the Conservatives for 6 minutes. Dr. Ellis.
Thank you very much, Chair, and thank you both ministers for being here. Minister Holland, in your mind, is having MAiD solely for mental illness a foregone conclusion at some point? Is that the destination we're going to get to?
It's my belief for folks who have an irreversible, irremediable mental illness from which they've sought all treatment and have been able to get no relief in many cases for decades, that eventually, when the system is ready, that people in that irremediable circumstance should have access to MAiD.
Thank you for that. How do you propose to get systems ready with the two outstanding issues of suicidality and irremediability?
Well, so suicidality is an issue that's completely separate and apart. If somebody who has having suicidal thoughts goes in and sees a clinical professional and seeks assistance, that's somebody who is able to be helped. Somebody who has a mental illness is somebody who, despite going and getting help for potentially decades, is unable to lift themselves out of that circumstance and is in an irremediable state that is in a state of decline, and so there's an important distinction to be made.
Thanks for that, Minister. You know, you talked about suicidality being an incidental thing, but realistically, it's part of the diagnosis of many mental illnesses. Is that not true?
Well, I don't, as somebody who suffered greatly and spoken publicly about my own mental health challenges, I do not believe that suicidality is at all incidental. What I'm trying to do is make a distinction between the folks that we're talking about in Bill C-62 and folks who are having a mental health crisis.
That was not the question I asked you. What I asked you specifically is suicidal ideation is an important part of a diagnosis of many mental illnesses. That's correct, is it not?
Yeah.
Simple question.
Yes, if you are mentally ill,
Thank you very much.
then that
so how
absolutely
do you expect,
can be present.
then, Minister, to get systems ready when suicidal ideation is a part of the illness that you're talking about? That doesn't make any sense.
Well, but what we're talking about is somebody not who has a mental health crisis and has suicidal ideation in a moment. We're talking about somebody who potentially for decades, and this is why we need to take time so that we can make sure that we are talking about the same cases. I'm sure
respectfully,
if I would
Minister,
posit
but when
to
you read the diagnosis...
Well, let me just posit so that we're talking about the same thing.
I'm asking the questions, not you. Thank you.
Go ahead, Dr.
When you
Ellis.
look at the diagnostic and statistical manuals, 5th edition, which talks about mental illness, suicidal ideation is an essential part of the diagnosis of, for instance, depression.
Well, so what I would say is, you being somebody who with a history within the medical profession, if you have somebody who has tried absolutely everything and has been suffering a mental illness for decades, at what point, at 1 decade, 2 decades, 3 decades, how long before that person has autonomy over their own decision? And would you not recognize the difference of somebody who's suffering for many decades
Minister,
and trying to get service versus somebody who's in a mental health crisis?
I'm talking about suicidality, which you said was something that came on suddenly, or I forget what your exact words were, but clearly that's not the case. The second part of it is irremediability. And what we know clearly with irremediability with respect to mental illness is that it's impossible to prove. There's many cases, you perhaps being one of them, who have gotten better from mental illness. And here we are today talking about irremediability. And we know that those two things, suicidality and irremediability, in no way are related to systems.
Well, irremediable means that you aren't able to remedy it. So it means that it doesn't get better. You don't get out of it. It means that somebody is trapped in an illness that doesn't allow them. And I think it frankly gets back to the point where physical suffering and mental suffering, and when there's an illness, which is a very different thing than having a mental health crisis. A mental health crisis is something you can get out of. Mental illness,
Minister,
where it's irremediable, means it can't be remediated.
Not mine. Is diabetes irremediable?
Well, I mean,
simple question.
Is diabetes? No. Diabetes is diabetes is manageable as a disease.
Mental illness is not manageable. Is that what you're saying?
There are certain mental illnesses that you would acknowledge and you've talked to doctors. I've talked to doctors. There's certain mental illnesses that people have not been able to escape.
Just as
there's cancer.
Point of order, Mr. Chair. Mr. Chair, point of order.
Point of order from Sidhu.
Mr. Chair, I just want to say the last panel, we said rules should be followed and without interruption, please.
Look, it's fine, Mr. Chair. I would say that, can I just make this point very briefly? Cancer is irremediable.
I'm the one
it
asking
ends
the
in
questions,
death,
not
and
you.
it is irremediable. I mean,
Holland, please.
trying to make an equivalency between multiple different illnesses I don't understand the point.
Last time, Sean.
Okay, Mr. Holland, you have, yeah, go ahead, Dr. Ellis. You've got another minute and 20 seconds.
Thank you, Chair. If I might remind you, Minister, I'm the one asking the questions, and if I have a question for you, as per the part of this committee, you need to answer it. The second part that we need to get to clearly is that this particular program that you have has a lack of safeguards. Substance use disorders and mental illness, post-traumatic stress disorder, which your government has offered to veterans as a mental illness, as is autism. How are you going to square your circle with respect to irremediability with those illnesses?
Well, I think, first of all, I guess we just have different purposes in discourse. I ask questions for seeking clarity and to get on the same page. We're trying to deal with a very difficult issue. When you're asking me the question about irremediability, I'm trying to say that if somebody has an irremediable condition, and we're talking here about not some other disease, we're talking about mental illness, somebody who's trapped in it. And I would ask you the question. I mean, and you say you don't want me to ask questions. My purpose of my question isn't a political point. It's one of clarity. If somebody is in a situation for 20 years, 30 years, 40 years, at what point, when they themselves are the ones asking for relief and are saying that they are in an irremediable condition?
Irremediability, though, you continue to say you need to get systems ready. Irremediability is something that you can't prove. You can't make a system to prove irremediability. It's an impossibility. That's a clinical judgment by a clinician in front of that patient. It doesn't matter what you change the system to, you're never going to get to the point of irremediability. We've heard from multiple experts that they are the ones that making that decision around irremediability, not a system.
Well, what I'm saying is that, and this is why I posed the question, because I think it's important for clarity. If you have somebody who is trapped in mental health that is saying that they want to end their life, and they say that for 5 years, 10 years, 15 years, 20 years, and they've attempted all therapy, they've attempted everything in their disposal, at what point do you feel that they have autonomy over that decision? If the answer is never, well, then that's an ideological position. And I can't really have, I mean, there's not a lot further to go. But if the point is that somebody at a certain point of suffering has an opportunity to have autonomy over their own life, then, that's an important debate and one that is not rooted in ideology.
Thank you, Minister. We're going to move to Dr. Hanley, please, for 6 minutes.
Thank you very much. Thanks to both of you ministers for appearing and for your officials as well. And I appreciate your opening comments from both of you as well. I want to just briefly go to continue on the train of irremediability and suicidality. So in your understanding, Minister, is determining suicidal ideation and distinguishing suicidality not already a part of MAiD assessment, even as currently applied to someone with a physical condition and mental illness?
100%. And one of the things in our conversations with provinces and territories is we want to make sure the moment somebody expresses suicidal ideation that they have access to care and are channeled to a pathway of treatment. So the circumstance, even for somebody who was attempting, who said where mental illness is the sole underlying cause, and they wanted to proceed with access to MAiD, even if this regime was permitted, they would need to demonstrate that they had tried everything, and there would have to be 2 clinicians that would have to validate that they had tried everything and that they, in fact, had an irremediable condition.
Step of interrupting you because I've got
No, go ahead, please. I was too long.
In your understanding, also, because you've had many conversations with practitioners, are there physical illnesses where irremediability requires judgment on the part of the physician?
Yes, in many instances, there are physical conditions where you are told by a clinician that your condition is terminal and irremediable.
So it's not necessarily a black and white decision or something that is in a textbook. It's a judgment that is required.
Correct.
As it may well be required for mental illness. So given that this is such a difficult issue, as we've all acknowledged, are you punting a difficult issue down the road?
No, I think if we were punting it, then we would have voted for MP Fast bill, which set no date, or would have set this off for an indeterminate length of time. What we've said, and I could run through, I want to be respectful of the time that you asked the question. I can run through specifically some of the things that I think need to happen. But we need time in order for our work with the provinces and territories to get to the position where there is system readiness, and that isn't present today.
Yeah, and thank you. The one-year extension that was applied a year ago, there were 4 criteria applied, and a national reporting system, MAiD practice standards to regulators in all provinces and territories, finalizing an accredited national MAiD training program, and considering the final report by the Joint Committee of the House and Senate. So which of these criteria, in your view, have not yet been met?
Well, I think there was excellent progress made. I mean, there was the development of the MAiD practice standards. There was the development and delivery of a national accredited MAiD curriculum. There were 1,100 clinicians who were registered, and I could go on. But I think one of the concerns is that there are only 2% of psychiatrists who've been trained at this moment in time, that of the 1,100 clinicians that have received training, only 40 of them have completed that training. And that, in talking with CAMH, there's the discussion about wanting to have clinical guidelines, and those would take time to develop. Lastly, if I could just very briefly, the engagement with Indigenous leadership. As I've gone and I've had these trilateral meetings, they're asking for more time, and specifically 2025. And this is also true of the community, of folks with lived experience in the disability community.
Thanks. The letter from 7 provinces and 3 territories, we all know about that letter. How influential was that letter in respect of the committee recommendations? How did each of those weigh into your decisions?
Well, I'll be frank. When I became health minister and I had initial conversations, because of the points that you've just raised, there was enormous progress made in a year, and I really felt that the system might be ready. In Charlottetown, what I heard every health minister say is that they weren't ready, that they needed more time. That caused me to have a pause at that moment in time, and led me to a lot of other conversations where I'm reflecting on some of the things that happened here. I would say the Joint Committee in its testimony and work was also very important in coming to that determination. So it was certainly a part of the equation, the position of the provinces and territories.
Okay. And let's say that letter came from maybe 1 province or 2 provinces and 1 territory. Like, how would that have changed? In other words, if some provinces are stating that they in fact are ready, how can we justify holding back when they say we're ready to go and we have all the systems in place?
Well, I think the inverse is, maybe I'll paint the picture in an inverted fashion, which is that there was no province, no territory. All 13 said that they are not ready. And I had very thoughtful conversations with many different health ministers who completely agreed in the equivalency between mental and physical suffering. However, they were requesting more time to get their systems ready, and then that was an earnest expression, I believe, on their part.
Can I just point out to Dr. Hanley that in Quebec they actually legislated the fact that for mental illness alone this should not be provided, so they took a more active step than the letter.
Thank you.
Thank you, Dr. Hanley. Suite, Monsieur Thériault, pour 6 minutes, s'il vous plaît.
And now, Mr. Thériault, for 6 minutes, sir. Yes, thank you. So the way the bill is structured, it really uses the Joint Committee's recommendations other than for the 3-year. But apart from the Conservative Party, everyone felt that we weren't ready, but felt that in a year it would be by then wiser to go ahead, and that was a good timeline. But it seems to me that there has been an excessive slowdown. How is it that the committee tabled its report and there was a decision to be made a few weeks before a deadline, then suddenly the province has come out with a letter and we haven't heard anything about it for the last year? How is it that you are allowing the committee to come up with recommendations which become a bill? But, it's really the elephant in the room, you're mentioning the constitutional rights of people who are suffering, but what are you doing for Sandra de Montigny? What are you doing for the principal recommendation, a majority recommendation of the committee a year back, which said that we need to go ahead with advanced directives? How is it that, though you had 1 year to prepare that track, so that the why is it being dropped? Why are people like Sandra de Montigny being brushed aside when there is a consensus across the land about her issue? It's a good question, and I appreciate your putting it to me. Of course, there are people who suffer greatly, and this is a horrible situation. I find it very worrisome. This said, it's clear that we need to make sure that the system overall is ready to launch this deep change to the MAiD system, because the consequences, if it weren't ready, would be very serious. Over the last year, we have moved considerably on this. It's quite remarkable, as I explained to Mr. Hanley, but it still doesn't suffice. On issues such as the, yes, thank you very much, advanced directives, this is such a complex matter. For example, in a situation where someone is in a bad state, there's a member of the family who says, yes, MAiD would be a good idea. The other member of the family says, no, that's not a good idea, and we're not even going to discuss it. The doctor says that the person themselves is incompetent, can't decide on their own. So there's a lot of situations like this. But let me stop you. This is disinformation. I mean, please, please, go and read the Quebec legislation. I mean, you lack rigor here. Of course, I'll hold back on this, but your response makes no sense at all to me. It's not a matter of members of the family, that one versus the other. In Quebec legislation, there's a third party who evaluates the situation. This is a third party who has been named ahead of time, and they are there to ensure that the person's will be respected based on criteria that person set out. And then the care team will say, look, I think the person is at this point. Will you please evaluate them? So a year ago, you came up with this recommendation. You were asked to deal with it. And now you're saying something as foolish as you are tonight. I mean, for heaven's sakes, I can understand why there's no bill before us, if that's your understanding of advanced directives in Quebec. And Quebec is unanimous on this matter. And 85% of people across Canada expect this as well, because people are suffering. What are you waiting for? At least this evening, could you agree that we'll go ahead with this bill before the end of this legislature, this government, and inform yourself? Yes, I can understand why people want access to a system with advanced directives. It's very logical. But my point is as follows, and it's very different from what's at issue here with this bill. It is possible today to say, in the future, if such and such a situation occurs, I would like such and such. But at that point in time, if the person were incompetent, unable to explain and state their situation and their need, imagine having someone else having to make the choice for them, the final choice. I mean, that's a major change, because another person would be making a choice on this issue. Now, of course, I'm very open to pursuing this conversation, and I would certainly like us to discuss this in depth with all provinces and territories. I can assure you we shall and are. But it's a complex matter. But look, come on. Neurodegenerative illnesses, these are physically degenerative, where it's clear they're irremediable, they are really heading to end of life. This is objectively visible and can be determined objectively. So that being the case, we can't think it would be any more complicated than mental disorders, or with mental orders where people are a little bit worried about whether it's irremediable or not. Of course, not everyone agrees.
The earlier panel, Mr. Doherty made an objection, which I agreed with at the time. We're not here talking about advance requests. We're here talking about C-62. It's a piece of legislation with a very specific outcome. And as much as I appreciate Mr. Theriault's passion, it's not on topic.
Thanks for the intervention, but we've allowed it all evening. I'm not inclined to change it now. It appears that the ministers are ready to speak to it. Please, Mr. Thériault, please, s'il vous plaît, posez.
Mr. Thériault, please put your question. And then we'll allow the minister 30 seconds to respond to it, because you're reaching the end of your time. All right. So will we have a bill? And will you please go and gather information so that we can ensure we could have that aspect covering people who are suffering? Will you examine the Quebec legislation and inspire yourself from it so that we can solve this once and for all? 85% of people back it across the country. Based on Ipsos, this is a real poll. So to begin with, 30 seconds. Yes, we're fully aware of the bill that has been carried and passed in Quebec. But what I can say, Mr. Thériault, is that from the outset in 2016, we have moved forward in a precautionary fashion prudently with the intention of involving the entire country. And this is how we responded to the Truchon decision. And this is also how we have dealt with advanced directives. We will carry out a study involving Quebec, of course, and Quebec leadership prudently. Thank you. Your time is up. And we gave you extra time as well.
For 6 minutes.
Thank you very much, Mr. Chair. Thank you, Ministers. Minister Holland, I'd like to start with you just on the subject of the letter that was signed by 7 out of 10 provinces in all 3 territories. Now, in our first panel, we had some witnesses talking about, readiness in the system, but I'm assuming that these ministers would not have signed this letter unless they had confirmed with their deputy ministers, assistant deputy ministers, that in fact their system was ready. Now, you've had in-depth conversations with these members. You've probably had conversations with their deputy ministers. What conditions would have to be in place for you to attach your name to such a letter? Like, you would probably want to consult with your deputy minister to get that kind of assuredness from the healthcare system that you're overseeing. Like, I mean,
the letter saying that would be indefinite as opposed to 3 years?
Well, no, just like what conditions would have to be in place for you to sign such a letter? Like, would you want to check with your deputy minister first?
I always would check with my deputy minister.
Okay, that's a good point to put into place. Also, these ministers were very careful to ask for an indefinite pause. What caused you to choose the 3-year delay instead of listening to the ministers who have that oversight of the healthcare systems?
So there were detailed conversations with the health ministers, and part of it was how long was it going to take their systems to get ready. And one of the concerns was some of the ministers, really it was a question of readiness, and they acknowledged the equivalency between mental suffering and physical suffering. But a few of them, were simply ideologically opposed to the idea of ever proceeding in such a way. And I think that if we were to put it off indefinitely, then we'd see no progress in the system in terms of adoption of the curriculum or even belief that we were moving towards that. And that would leave people who are in unimaginable suffering, right? And we're talking about a very small number of people, but these are people who have tried everything and are stuck in unimaginable mental hell. And after, in many cases, decades of asking, are saying, I want access to MAiD. And so that is a consideration here.
Thank you. I'm going to take issue with 2 of your earlier comments. I do think, actually, this issue has been punted down the road. It was punted down the road by 2 years with the Senate amendment. It was further punted down the road by 1 year of C-39. Now we're looking at a 3-year punt. I also take issue, I've been on the Special Joint Committee since its inception. I agree with the recommendation that we put forward, but we did not have anywhere near enough of a time frame to study this issue in depth. We had 3 meetings, 3 hours each. So how can you say that this is not punting down the road, and how can you say that the Special Joint Committee had adequate time when in fact we did not?
Well, this, of course, was the second time the Joint Committee had been sitting, and the Joint Committee, in its previous iteration, had spent an extraordinary amount of time on the subject. So it was round two, if you will, for the special Joint Committee, and we're very appreciative of their work. But they did extensive work in the first round, and that wasn't very long ago. So, and the second point was that there seemed to be a uniformity of opinion within that Joint Committee that more time was needed. So, I don't know how much time you need to study once you reach a conclusion that you need additional time. Keep studying to say you need additional time doesn't make a huge amount of sense to me. But in terms of punting down the road, I mean, you can use whatever nomenclature you want. The point here is that we have to ensure the system is ready. And if given the opportunity, I could talk about all the things that were done over that 1 year period and why we thought they would be sufficient. But the underlying reality is that it was insufficient and we needed more time. And I wish I had clairvoyance and could have known that, but lacked it.
Thank you. I'd like to turn to Minister Varani, if I could. Minister Varani, you said, you were, to paraphrase the Supreme Court, you were mentioning that they were going to give a high degree of deference to Parliament when legislating in this area because of how sensitive it is. Now, when C7 was first introduced, I thought there was a very reasonable charter statement issued which explained the government's initial reasons for excluding this. Then at the 11th hour, a very consequential Senate amendment was accepted. And that really, I think, is the root of all the problems that we're finding ourselves in today. Do you, as a minister now, have regret about that decision? Because I truly believe that decision was putting the cart before the horse. And speaking as a member of the Special Joint Committee, Minister, we have been playing a game of catch-up ever since. The law was changed in advance of the important consultation, in advance of those committee hearings. And as a result, we have had to constantly shift the timeline. So, again, why didn't the government exercise that high degree of deference, as you put it, that the Supreme Court gave you the room to exercise in the first place?
Well, I think there's sort of two issues there, Mr. McGregor. So the issue is what deference is accorded by the Supreme Court and your criticism of our response circa 2019, 2021 vis-a-vis mental illness. Do I regret that decision? Not at all, because I think what the Senate prompted was an active discussion about mental illness and the evolution of this law and its potential expansion and the development of the MAiD curriculum, the model standard, things like oversight mechanisms that are under development is all a byproduct of that function. And I think that's proper vis-a-vis showing equivalence between mental suffering and physical suffering and not perpetuating negative stereotypes that the mental suffering does not deserve the same level of sort of treatment or being addressed, and also pejorative assumptions about people's decision-making capacity who are mentally ill. What I would say to you is that on the deference piece, Mr. McGregor, is that the court has said that there's a certain amount of deference owed as part of the parliamentary dialogue, the dialogue between courts and Parliament. There's extra deference showed in a matter of complex social policy. And then they highlighted in the Carter decision that when it comes to MAiD, that deference is directly applicable. So what they're saying there is that they're going to allow a margin of maneuver for parliaments to try and get this right when you're balancing delicate interests. And I'll say to you what I said at the outset is that when you've got issues of the unpredictability of the course of one's mental illness, when you've got the possibility of suicidal ideation being a symptom of someone's condition, you've got to make sure that while I firmly believe you can distinguish between suicidal ideation and a well-considered, well-thought-out request for MAiD, that difference can be made, that distinction can be made, but we have to ensure that all of the healthcare practitioners, MAiD providers and assessors have the ability to do so. And when only 40 people have had that education, I think that's not enough.
Thank you, Minister. Mr. Cooper, please, for 5 minutes.
Thank you, Mr. Chair. Minister Holland, you have repeatedly claimed this evening that the only persons who would be captured by this expansion of MAiD for mental illness are persons who have been suffering with an irremediable, irreversible mental health condition for a prolonged period, decades, and have sought all treatment options. That is false, and you know it to be false. Minister, on what basis can you peddle such a false claim?
So I would hope that anybody who's in a mental health crisis would come forward and would seek mental health services. And of course, under the regime that we're contemplating here today, that would mean that somebody would get help. They would not have access to the regime. And what I'm saying, sir, is that the people that I'm speaking to, these are very real cases with individuals who are trapped in mental
Minister,
health.
it's my time, and my question.
Go ahead, Mr. Cooper.
Again,
Go ahead, Mr.
There
Use
are
it as you
no
will.
legislative safeguards, none whatsoever in the case of MAiD for mental illness. All that would be required is for someone to have the sign-off of 2 clinicians, not even a psychiatrist, not even a medical doctor necessarily, and they would then have the green light and would be eligible within 90 days. So what are you talking about when you talk about safeguards? Because there aren't any.
Well, that's just not true. And Minister Varani can speak to it as well, that the intention, I mean, first of all, let's reverse this. I mean, the accusation in the way that you're coming at me is if somehow I don't care about people and their mental health.
You made a very specific claim repeatedly.
You're being extremely aggressive with me and not allowing me an opportunity to express. So I understand you have a political point to make. It's a question of whether or not you want to hear my answer.
It's not a political point. It's about
Miss-
truth.
Go ahead.
Mr. Cooper, you're holding him a little too tight on the timeline. Take another 10, 12 seconds on this question. We'll move to the next. Okay, go ahead.
The safeguards are you must be informed of available and appropriate means to relieve your suffering, including counseling services, mental health, disability support services, community services, palliative care. Person and practitioners must have
discussed. It's my time. I'm reclaiming my time. I'm reclaiming my time. If you're referring to the, and I'll go back to Minister Holland.
Go ahead, Mr. Cooper.
I'll go back to Minister Holland. If what is being referenced are the so-called model practice standard, that has no teeth. That is very different from a criminal code safeguard. And with respect to that so-called model practice standard, there's nothing there that provides guidance on the lengths, numbers, and types of treatments, nothing that all treatment options be exhausted by the patient. So in the face of that, how can you possibly claim that this will impact only a small number of people who've suffered over a prolonged period of time? That's simply false, and you know it, Minister.
Well, you can say that. It doesn't make it true. And secondly, you won't allow us to enumerate the ways in which there are safeguards. So you say there aren't safeguards, and then you aggressively talk over me as we try to talk about what those safeguards are. I would simply posit to you that the eligibility criteria is extraordinarily strict, that the model practice standards being incorporated by the provincial regulators will be similarly strict, that the criminal code, if somebody violates those, is a criminal violation. It is not a light matter, and that my interest has been expressed.
My time, and I would cite,
and you're certainly making it clear what your time is about, sir.
Here's a fact. There was a survey released from the Ontario Psychiatric Association that provides that 78% of Ontario psychiatrists, this was released 2 weeks ago, are of the view that the current so-called safeguards are insufficient and will result in the inappropriate applications of MAiD for persons who are struggling with mental illness. In other words, wrongful deaths. Why would Canadians believe you and trust you over 78% of Ontario psychiatrists?
First of all, my interest, like yours, is to protect life and to make sure that people who are suffering get every opportunity to get the help that they need. Two, that the situation that exists right now is asking for additional time, because we do believe safeguards are present, and I've talked about some of those, but we think we have to go that much further to make sure those safeguards are there, so that people that are trapped, and by the way, we're talking about people in their own volition in an irremediable mental illness circumstance.
Minister, there are no legislative safeguards.
Well, you can say that.
Well, you haven't cited one. You haven't cited any.
Yes.
You haven't cited any, and you haven't responded to the fact that 78% of Ontario psychiatrists believe that whatever so-called safeguards that will be in place are completely insufficient. We're talking about wrongful deaths when there's an inappropriate application of MAiD. That's what we're talking about.
So we're talking here, and see, in this legislation,
is what you've demonstrated is that
No, we're
you're
taking.
ideological.
First of all, I'm just going to say I reject.
You're playing with people's lives.
I reject that totally. I reject
it's absolutely disgraceful.
No, what is disgraceful is mischaracterizing my position or mischaracterizing the position of any member of Parliament, sir. Saying that any member of Parliament doesn't care about any human life is a disgraceful thing that I will not tolerate.
Well,
and for you to step into this committee and make an accusation of any member of Parliament that they do not care about the life of another human being is absolutely beyond reproach, sir. I have spent my entire life, as you have, fighting for the good in this world. And for you to accuse a good person of not caring about human life, shame on you. Shame on you.
Mr. Chair, if I could just point out that the safeguards that I mentioned are in the Criminal Code of Canada. That is a legislated safeguard. We also have protections, save for exceptional circumstances, against compelled treatment in this country. That's protected under the Charter. Thank you.
Next up, we have Mr. Johari, please, for 5 minutes. Someone over on the Liberal side, Mr. Nakvi, please, for 5 minutes.
Thank you very much, Chair. I do want to go back to the safeguards because I think that's a very important conversation to have. So starting with you, Mr. Virani, why don't you outline the legislative safeguards that are in place, and perhaps, Minister Holland, you can then talk about the safeguards that are being put in place through the medical community in order to administer MAiD properly.
So let me start with the legislated safeguards that are in legislation called the Criminal Code of Canada. The MAiD request must, so we're talking about track 2, which is where death is not reasonably foreseeable. You must make the request in writing. 2 independent doctors or nurse practitioners must provide an assessment. The person must be informed that they can withdraw their request at any time and in any manner. The person must be informed, to Mr. Cooper's point, of available and appropriate means to relieve their suffering, including counseling services, mental health and disability support services, community services, palliative care, and must be offered consultations with professionals who provide those services. The person and the practitioners must have discussed reasonable and available means to relieve the person's suffering and agree that the person has seriously considered those means. This assessment must take at least 90 days. You can pause it, and what I've heard anecdotally is that in the context of mental illness as a sole underlying condition, it would likely take much longer than 90 days. And lastly, you must provide final consent immediately before MAiD is provided. All of those safeguards are legislated. These are not practice guidelines, practice standards, etc. Those are in the Criminal Code of Canada under the MAiD provisions. I'll turn it over to Minister Holland.
So just very quickly, just to cap that part off, so by legislative means, being in criminal code, that they have the full force of law as it relates to the Criminal Code of Canada behind those safeguards.
That is correct.
Thank you. Minister Holland.
Thank you so much. Look, this is, as I get an opportunity to talk with clinicians, doctors, nurses across the country, all of them are, trying to get this right and deeply concerned about their patients. And that's why I get so upset, because I think, as parliamentarians, casting aspersions on people's motives, trying to insinuate that somehow anybody's not caring about human life is just deeply irresponsible. In my experience, those that both develop the national accredited MAiD curriculum, those who develop the practice standards, those that are in the system are trying deeply to work with people who are in extraordinary pain. Talking to a doctor who has a patient who's been coming to them for decades in unspeakable pain. And that doctor says, I can't do anything for this patient. We've tried everything. And that patient is asking for a way out. It is extraordinarily painful to hear that. And you can have an ideological position that you don't want to deal with that, but I think that understanding that navigating this and trying to work with the provinces and territories so they have appropriate safeguards, looking at CAMH suggestions around clinical guidelines, I think is entirely appropriate, because we do have to make sure that those safeguards are as strong as possible and that we are only dealing with those remote and most unusual of cases.
So it is a very difficult place for us as parliamentarians, of course. to make sure that those who are responsible to administer the system feel confident that they have all the systems in place. And so I believe personally that it is prudent for us to grant this extension so there's no doubt the system across the country with the equity that we want to make sure is available. And I give a fair bit of credence to the letter that you've received that is before us from 7 provinces and 3 territories. And the part that got my attention, which says it is critical that all jurisdictions, health authorities, regulations, and MAiD practitioners have sufficient time to implement these safeguards and to address capacity concerns that are expected to result from the expansion of MAiD eligibility. The current March 17, 2024 deadline does not provide sufficient time to fully and appropriately prepare all provinces and territories across Canada. How much was that an influence in your decision to bring forward this particular piece of legislation?
Well, certainly it was a significant contributing factor, as I've indicated earlier. I think that, I have a very good working relationship with and talk nearly every day with my provincial and territory counterparts. And so when they say that their system needs more time, I take that very seriously. They put that in a letter to us and have been clear that they want to look at additional safeguards, potentially saying that they want a psychiatrist to be present and involved in every instance, asking again about this issue of clinical guidelines. So, I think that listening to the provinces who are responsible for the administration of those programs is critically important, and certainly it played a significant role in the decision to also listen to the Joint Committee's work.
Thank you very much.
Next, we have Monsieur Thériault pour 2 minutes et demie.
You have 2.5 minutes, sir. Well, indeed, there are the legal safeguards and there are the clinical safeguards. In the regulations that will devolve from the legislation, from the Act, would there be, well, could we put in the Act itself something about Recommendation 10 of the expert panel's report? I think that would be a good idea. I know that what we will eventually carry or pass has nothing to do with that because we aren't at a final enactment yet, but it seems that that would be useful work to carry out. Another matter of relevance when it comes to mental disorders, Recommendation 16 about surveillance review, not retrospective, but looking forward. Quebec has set up a plan to annually report on the application of these approaches. When it comes to mental disorders, we would need a provision that would be foresight, really, before anything took place. Let's say it's admissible, the patient is eligible, they've gone through all the different questions and stages, and then there's a committee at the very end that examines, that reviews the whole procedure to ensure that it's adequate and respects all the safeguards, both legal and clinical. It seems that would be very relevant. It seems an important thing we should do, particularly with regard to mental disorders, given that experts are of differing opinions, and if we want to ensure that the approach is adopted calmly and has social support. As soon as this bill passes, when it comes out of the Senate, what will be the steps we will need to undertake immediately? Because this is the problem we've faced since the outset with MAiD. You see, we've just waited on this, waited on that, and then there are continuous requests to extend temporary exclusions and so on and so forth. What will we do the day after this legislation receives royal assent so we can move forward? Well, it's not just a matter of working of the Senate passing the legislation and waiting for them to do any work. We're working on a day-to-day basis already with each province and territory to improve the system's capacity to deal with these difficult issues, to hold the conversations that are needed about directives, advanced directives, and so on, and many other aspects, and to continue the training to ensure that we are ready for this eventual change, because it's not going to be an easy one. It's such an emotional topic. Mr. Thériault, your question lasted for over 2 minutes with the answer, and you are out of time. If you have any other thoughts, go ahead. But Mr. Thériault's time is up, I'm afraid. No, good. No, I'm afraid. No, I'm afraid there's no continuing at this point.
Please, for 2.5 minutes.
Thank you, Chair. I want to ask one question of each of you in the 2.5 minutes, so please respect the time that I have. To you first, Minister Virani, I have heard the constitutional arguments thrown on both sides of the equation. As Minister of Justice and the Attorney General of Canada, is there an interest from your department in referring this issue to the Supreme Court of Canada?
The matters of complex social policy are for Parliament to determine and for courts to evaluate after the fact. There is no interest in pursuing a reference right now, and an abstract reference question can even be denied to be answered by the court.
Okay, thank you for answering that. Minister Holland, you know, in my riding at Couch and Malahat Langford, and I understand the differentiation between mental health and mental illness, but, you know, when I go around my riding in particular sections, in particular communities, it's quite obvious that many people are suffering from a mental illness. You can see it right on the streets. I think some of the concerns that have been raised, and I take the point of the legislative safeguards that exist in the criminal code, there still is a very real concern that because of an individual's circumstances, the fact that they may come from a disadvantaged population, they may not have had the same access to services through their life, there's a very real concern that they may still be able to satisfy the legislative safeguards in the criminal code, but they may have been sent down that path because of the life circumstances they find themselves in. So how do you, as Minister of Health, given the great needs that we have and are very evident across our country, how do you resolve that as a minister with such a very sensitive issue?
Well, I thank you so much for the question, and I acknowledge that to be true. That that often there's a direct correlation between those that have suffered the most and those that are in the worst state of mental health. And sometimes when somebody has a mental illness, which again is different, it can certainly be greatly exacerbated by trauma or by those very difficult circumstances of which you speak. And so one of the reasons why I think we need time is we need to make sure that we get that line exactly right to the point that you're making, that we don't want to wind up in a circumstance where somebody, articulates a desire to, they have a mental illness and they pushed and there was something that we could have done. Like we have to exhaust everything, and it can really only be at the end of the road after we've tried everything and we've been able to find no solution, where, I think we're left with that question, what do we do as a society? If somebody has tried absolutely everything and is at the end of the road in terms of pain and wishes of their own volition then to end that, that's a complicated, difficult question. That's why I think we have to take time. But I acknowledge the circumstances that you're talking about. It's one of the reasons why at the onset I said those conversations with many of those disadvantaged communities, I think are so essential to make sure that they're fully comfortable that the controls are in place and that we're proceeding in the appropriate way.
Thank you, Minister. Thank you, Mr. McGregor. We are almost at exactly 1 hour. I propose one question each from the Conservatives and from the Liberals, and please keep the questions and answers short. It's been a long day for everyone. Over to the Conservatives. One question.
Minister, I want to start with this. I believe that your outburst earlier was inappropriate, and I believe that it was very charged, and I find it. I believe that you owe not only the committee members here an apology, but those that were sitting beside you, if you could see the looks of shock on their face when you had your outburst, an apology.
Please get to the question, Mr. Doherty.
The question I have for you is substance use disorder a mental illness? You going to answer?
First point, I did become emotional, and I apologize for that. I think that it's so terrible. I have never done this, to cast aspersions, and particularly to accuse another member of advocating for death. and not caring about human life. And I think at a certain point we have to draw lines in our discourse. At a certain point we have to say there are boundaries and places that shouldn't go, and that there are things that are inappropriate. And I would suggest that Mr. Cooper making a suggestion that I or any member of Parliament doesn't care about human life or is irresponsible and is something that at some point in time, yes, will elicit an intemperate response.
Okay. Mr. Doherty also asked a question about whether something was
Is substance use disorder a mental illness?
If you could just answer that.
I think that, that we have a crisis, absolutely, with substance use in this country, and that substance abuse almost, in many, many instances, has as its root a mental health concern, yes.
Is it a mental illness,
Thank you. Thank you both. The last question over to the Liberals, Mr. Maloney.
Yeah, thank you, Chair. Thank you, both ministers. My question is going to be for Minister Holland. Look, this is an emotionally charged debate. I don't think anybody needs to apologize for demonstrating passion when they're discussing this. I've been involved in this process since very, very early on, along with Mr. McGregor, Mr. Cooper, and others. Look, we're dealing with a very specific issue, and that is whether to postpone the implementation of MAiD solely for the purpose of mental illness. We're not here to debate constitutionality. We're not here to debate, advance requests. We can debate the morality. These discussions are going to take place in another context. So my question is this, and I put this to a witness earlier. I feel the only responsible thing I can do as a legislator, and I think people around this table agree with me, is that regardless of what side of the discussion I fall on, if I'm faced with a lack of consensus by professionals, that the only responsible thing I can do is to postpone it until to allow for further discussion. So two parts of my question. That's the first part. Do you agree with me? And the second part is on the timeline. You've introduced a piece of legislation what postpones it for 3 years as opposed to indefinitely. And Minister, you addressed this briefly earlier, but is the reason for doing that not to advance an agenda, but to keep it on the agenda? Because otherwise it can just fall into Never Never Land. Thank you.
I think that's an entirely appropriate way to characterize it. I think that the concern with putting it off indefinitely is that we leave those people, and there's not many, but they're there, who are in intractable, horrifying conditions, trapped in mental torture with no prospect of us moving towards any possible solution. So it creates an imperative to act and an imperative to keep moving. And in 2 years' time, Parliament will get the opportunity once again to conduct a parliamentary review and to evaluate the state of readiness at that time.
Thanks.
Point d'ordre, Monsieur le Président. Point d'ordre.
Oui.
A point of order, Chair. Yes. The bill now before us has been mentioned several times by the Bloc Québécois in an attempt to discuss advance directives. So I don't accept our saying that it can't be discussed here because it has nothing to do with the topic.